Good afternoon, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. We'll get to the JRC's nonsense here in a moment, but first, the disclaimers and the trigger warnings. If you're unfamiliar with the Stop the Shocks campaign or the campaign against the troubled teen industry, pertinent links are going to be there in the description box. Please take note of Autistic Korea's massive archive on all things Judge Rotenberg Educational Center. We also have the article written by Neuroplastic, where they interviewed over 800 ABA professionals in regards to the JRC's so-called behavior modification program. It is indeed the same article that the JRC threatened a defamation lawsuit over if they didn't remove it from their website. Obviously, Neuroplastic refused, so please read the article, share it on all your social media. Also included is Neuroplastic's GoFundMe link in case the JRC actually ever does see through with their threat, because unlike them, we do not have access to unlimited streams of money. Trigger warnings: when we discuss places like the Judge Rotenberg Educational Center or Agape Boarding School for Boys, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with mental health issues and disabled people being tortured and abused. If you got young children present, please utilize the headphones. Also, this channel is marked not for kids for a reason. We use profanity and speak on dark subjects. If your child's 16 and younger and they are watching this, parental supervision is very much advised. Now, we're not going to recap the last video because there was just entirely too much stupid there, where the JRC is trying to say, but we have information that contradicts, like that avalanche of hard, cold facts that we all have access to. Funny how they never seem to present it, though. And instead tried to make us accept way outdated clinical studies that have nothing to do with their device. We're just going to cut into it and get straight to it. We'll try to get through half of the paragraph, but who knows? One can only tolerate so much stupid, and damn it, it's Friday. This is my have fun day. Alright. Indisputably, there has been substantial reliance here. Again, I ask you, JRC, whose reliance? Whose reliance? Is it the patient's reliance? The JRC would like, well, yes, they depend on it. Do they? Because I'm pretty sure if I'm being shot and I'm screaming at you no, and I'm begging you to stop, it's not me that's relying on the device here. It's the individual forcing me to wear it and forcing unwanted, extreme, intense pain upon me through it that is relying on it. Okay? Let's continue here. For over 25 years, the FDA knowingly and explicitly authorized the use of the ESD treatment, and specifically GED treatment. That is a lie. That is a lie. We know by the evidence and the facts that the FDA only approved a singular device for you to use at your school, which was the first iteration of the GED device that you were able to obtain licensing and approval for in 1991. All other iterations of the device have not been approved by or licensed in regards to the FDA. Okay? In fact, the FDA has extensively and multiple times have tried desperately to get a hold of you and set up appointments so that those devices could be properly tested and vetted. The FDA made us aware of the fact that they've called with no answers, called and gotten answering machines, called and have been put off. So, what we're actually looking at is you had one device approved, then over 24 years of dodge and wave. No GED device since then has been approved by the FDA. In spite of how many times they have tried to reach out to you and get those newer devices properly vetted. This is explicitly stated in both the final ban that was put through in 2020 and also mentioned in the proposed ban that went forward back in 2014. So, as per usual with the JRC, that is a lie. They have not authorized your use for any of the current iterations of the GED device at all. Just the first one in 1991, and ever since then, with each new iteration, you've been dodging and weaving as though if you let them test the device, you'll contract a very fatal case of the bubonic plague. Okay? Facts matter. Let's continue here. As a result, the parties came to rely upon ESD treatment and believed that they would have continued access to this therapy of last resort, which had finally provided effective treatment for these patients. My God, if their lips are moving, they're lying. Again, who's relying on this treatment, JRC? Is it the poor people who are having that device forced on them? No. They do not rely on it. They want you to stop. We've got literally tons and tons of evidence to prove that. The individuals who are relying on that device is you. You're relying on it. You are the party that's relying on it. But the parents approved. Don't make me tap the sign. Alright? I'm not even going over that again because it just gets absolutely annoying to have to continue to repeat myself over and over and over again. For real. Just shy of 20 years is more than enough. Just saying. So, another thing. We know, because we have access, due to Jennifer Masumba bravely waiving her HIPAA rights, so that we could have access to her so-called behavioral contract. Within that contract, we saw, quote-unquote, shockable offenses that were not last resort at all. Someone standing up for longer than 3 seconds without verbal permission, getting shocked, that's not a last resort. Andre McCollum's telling you no, he would not remove his coat, and then you proceeded to shock him face down with a noise helmet on a 4-point board 31 times over a 7-hour period. That was not last resort by anyone's definition. Now the JRC has tried to justify it by saying, well, but that 3 seconds up could be start of an aggression. Oh, but don't worry, it gets worse. If you raise your hands to your forehead right here, you all remember that, right? Shockable offense. Well, they could go immediate self-injury. Are you psychic? Can you say beyond a shadow of a doubt whether that hand was simply just going to rest on the forehead, like, most of us in school have done at some point in time, or whether it's going to gouge their eyeballs? No, you're not God. You're not psychic. You have no way of knowing which one that was going to be. Which means you do not use it as a last resort. You use it as the first resort for anything and everything. If they breathe in the wrong general direction that you don't approve of, you shock them for it. You all know the saying, you can't lie when we have the receipts. Right? But it's been effective. Yes, violence is effective. That doesn't mean we need to bury it with medical treatment. What's there not to get there? What is there not to get? Again, I could have my brother here living with me, rent-free. Rent-free. So that if I stimmed in a way that somebody didn't like, or maybe they didn't like that I woke up cranky and started glaring at people with my mom's patented special level evil glare that makes grown drill sergeants take several steps back. Am I going to get shocked for that? Or, and therefore, because I did that, and he couldn't assume that I wasn't going to become aggressive with that glare, have him punch me in the face, and then call that treatment? No, nobody in their right damn mind would say that that was proper treatment. But here you all are, spouting nonsense. Because there is no legitimate way to defend this insanity. You have no evidence, you have no facts, you have trust me brah, and that this is the only thing that works. In actuality, your lack of knowledge in regards to the field that you are trying to tell us you are expert in is absolutely mind-blowing. There are kids that are graduating high school, disabled kids, who have a better knowledge in regards to this field and the different treatment programs and community-based programs out there than you folks do. I know I've talked to them. I've seen them at People First meetings, at ASAN meetings, at APSI, our Employment First Initiative groups, folks. That's what APSI is. So yeah, last resort my ass. Let me continue. During this period, the FDA considered the devices to satisfy its requirements for safety and effectiveness and represented this position to the JRC. That is a lie. That is a lie. Oh, we got another one. From 2000 to 2011, the FDA considered the devices exempt from regulation under the practice of medicine exemption and advised JRC of this position. You know what? I'm ready to call bullshit again. How about you all? We have to tolerate their stupidity far too much. Let's call their bluff again. What do you all say? Let's do it. Let's take a look here. Okay, maybe for once they're not lying. Let's take a look here. Explanation. FDA initially determined that the devices which were used to deliver electric shocks as a behavioral intervention fell under the practice of medicine exemption, meaning they were not subject to FDA regulation. Okay, so during that period of time, they were under the impression that they did not have the authority there, which is why in 2020 the original ban was overturned. Since then, Congress has given that power to the FDA to be able to have that jurisdiction to push through the ban. Hence why we are going through all of these comments again. So, okay, in this area, I was incorrect. I'm going to read up a little bit more on it and then close out for the video here. This meant that the FDA did not require the devices to be approved for use, nor did they have to meet certain safety and effectiveness standards. God, that's dangerous. The FDA's position was communicated to the JRC during this period. Okay, now, however, context is king, folks. How many times have I said it? Context is always king. However, in 2011, the FDA changed its position and began to consider the devices as subject to regulation, leading to a ban on their use in 2020. 2011, folks. The trial in regards to what happened to Andre McCollins commenced in 2012. This was a year before that video went viral. Let's read it again. However, in 2011, the FDA changed its position and began to consider the devices as subject to regulation, leading to a ban on their use in 2020. The FDA's decision to ban the devices was later overturned by a federal court, which ruled that the FDA had overstepped its authority by regulating the practice of medicine, an area traditionally regulated by the states. In response, Congress amended the Federal Food, Drug, and Cosmetic Act to allow the FDA to ban medical devices for specific uses, regardless of their approved uses. So, there we go, folks. That is the truth. So yes, they are correct. During that time period, till 2011, they told the JRC that. That position was then changed as the FDA learned more probably in regards to the device and put through the final ban. Now, the appeals court overturned that in 2020, so Congress then amended the act to give the FDA the authority to see through with the ban. So, we were not given full context. That's the sort of thing that the JRC always does, isn't it? They either out and out lie, or they remove the entirety of the context. Right? Okay. We're going to get into more of that paragraph after this weekend. I really do need the rest from JRC Stupid. And we've got a lot to go over still in regards to Medicaid, especially because the evil bastards went ahead and approved the cut, at least in Congress. So we're going to be coming out with that tomorrow and on Sunday. But for now, folks, we don't get very many views on this channel. The few we do get do tend to get removed from time to time. So if you could, folks, please don't forget to hit the like button, hit subscribe, and please don't forget to hit the comments. I do appreciate your time. And as always, folks, we here at Spilling Tea absolutely hope you have a good one. I will see you all tomorrow. Bye-bye, everyone.